Convention. Finds unanimously that the complaints by the this is the third point. Finds unanimously that the complaints by the applicant Ukrainian government concerning events which took place in the Russian Federation or in territory in the hands of the Russian armed force from the 24th of February 2022 to the 16th of September 2022 fall within the jurisdiction of the Russian Federation within the meaning of Article 1 of the Convention. 4. Finds unanimously that the complaints by the applicant's Ukrainian government concerning military attacks by separatists or by the Russian armed force fall within the jurisdiction of the Russian Federation within the meaning of Article 1 of the Convention and dismisses the preliminary objection raised by the respondent government in that regard. 5. Holds unanimously that has been a violation of Article 2 of the Convention under its substantive limb in respect of the downing of flight MH17. 6. Holds unanimously that there has been a violation of Article 2 of the Convention under its procedural limb in respect of the downing of flight MH17. 7. Holds unanimously that has been a violation of Article 13 taken together with Article 2 in respect of the downing of flight MH17. 8. Holds unanimously that the suffering and the next of kin of the victims of the downing of flight MH17 fell within the scope of Article 3 of the Convention and that there has accordingly been a violation of that article and dismisses the preliminary objection raised by the respondent state in that regard. 9. Holds by 16 votes to 1 that it is not necessary to examine separately the complaint under Article 13 of the Convention taken together with Article 3 in respect of the downing of flight MH17. 10. Declares unanimously admissible the applicant Ukrainian government's new complaints in application number 11055/22, namely A. The complaint of an administrative practice under Article 3 consisting of causing suffering exceeding the minimal level of severity through unlawful military attacks and abductions and forced disappearances. B. The complaint of an administrative practice under Article 8 of the Convention consisting of the forced displacement and transfer of civilians, the involuntary displacement of civilians and prevention of their return home, the application of filtration measures, the destruction of homes and personal possessions, and the theft and pillage of personal possessions. C. The complaint of an administrative practice under Article 11 of the Convention, consisting of unlawful interference with the right to peaceful assembly. D. The complaint of an administrative practice under Article 2 of Protocol 1 to the Convention, consisting of a failure to ensure a right to access education facilities and indoctrination of students. E. The complaint of an administrative practice under Article 14 of the Convention, taken in conjunction with the above articles in respect of the above complaints. F. The complaint of an administrative practice under Article 13 of the Convention in respect of administrative practices in breach of Article 2, 3, 4, Paragraph 2, 5, 8, 9, 10, and 11 of the Convention, Article 1 and 2 of Protocol 1 to the Convention, and Article 2 of Protocol 4 to the Convention, and the remainder of the new complaints are inadmissible. Point 11 of the operative part. The Court holds unanimously that there has been an administrative practice of military attacks in violation of Article 2, 3, and 8 of the Convention and Article 1 of Protocol 1 to the Convention, and that it is not necessary to examine separately complaints under Article 9 and 10 of the Convention and 2 of Protocol 4 to the Convention in respect of this practice. 12 holds unanimously that there has been an administrative practice of extrajudicial killing of civilians and Ukrainian military personnel hors de combat in violation of Article 2 of the Convention. 13 holds unanimously that has been an administrative practice of torture and inhuman degrading treatment in violation of Article 3 of the Convention. 14 holds unanimously that has been an administrative practice of forced labor in violation of Article 4, paragraph 2 of the Convention. 15. Holds unanimously that has been an administrative practice of unlawful and arbitrary detention of civilians in violation of Article 5 of the Convention. 16. Holds unanimously that has been an administrative practice of the unjustified transfer and displacement of civilians and application of filtration measures in violation of Article 8 of the Convention. 17. Holds unanimously that has been an administrative practice of intimidation, harassment, and persecution of religious groups, aside from the UOC MP in violation of Article 9 of the Convention. 18. Holds unanimously that has been an administrative practice of unjustified interference with the freedom to impart and receive information and IDs in violation of Article 10 of the Convention. 19. Holds unanimously that has been an administrative practice of unjustified interference with the right to peaceful assembly in violation of Article 11 of the Convention. 20. Holds unanimously that there has been an administrative practice of destruction, looting, and expropriation of the property of civilians and private enterprise in violation of Article 1 of Protocol 1 to the Convention, and insofar as this practice concerns the destruction and looting of homes and personal possessions in violation of Article 8 of the Convention. 21. Holds unanimously there has been an administrative practice of suppressing the Ukrainian language and indoctrination in education in violation of Article 2 of Protocol 1 to the Convention. 22. Holds unanimously there has been an administrative practice of the transfer to Russia and in many cases the adoption there of Ukrainian children in violation of Article 3, 5, and 8 of the Convention, and that is not necessary to examine separately the complaint under Article 2 of Protocol K to the Convention. 23. Holds unanimously there has been an administrative practice of failing to secure the rights and freedoms set forth in Article 2, 3, 4, paragraph 2, 5, 8, 9, 10, 11 of the Convention, and Articles 1 and 2 of Protocol number 1 to the Convention, without discrimination on the grounds of political opinion and national origin in violation of Article 14 of the Convention. 24. Holds unanimously there has been an administrative practice in breach of Article 13 of the Convention taken in conjunction with Article 2, 3, 4, paragraph 2, 5, 8, 9, 10, 11, and 14 of the Convention, and Article 1 and 2 of Protocol 1 to the Convention. 25. Holds unanimously that the respondent state has failed to comply with its obligation under Article 38 of the Convention. 26. Holds unanimously that the respondent state must, without delay, release or safely return all persons who were deprived of liberty on Ukrainian territory under occupation by the Russian and Russia-controlled forces in breach of Article 5 of the Convention before the 16th of September 2022 and who are still in the custody of the Russian authorities. 27. Holds unanimously that the respondent state must, without delay, cooperate in the establishment of an international and independent mechanism to secure, as soon as possible and with due consideration of the children's best interests, the identification of all children transferred from Ukraine to Russia and Russia-controlled territory before the 16th of September 2022, the restoration of contact between these children and their surviving family members or legal guardians, and the children's safe reunification with their families or legal guardians. 28. Holds unanimously that the question of the application of Article 41 of the Convention is not ready for decision and adjourns consideration thereof. 29. Joins unanimously application number 28/525/20 from application number 8019/16, 43/800/14, and 11055/22 for the purposes of the further proceedings only. This concludes this morning hearing, and I accordingly declare it closed.